going to spend the next few hours, 2-3 hours, talking about drug and alcohol testing. This is a topic that just never runs out of questions, right? We get calls all the time, Amber and I, related to this topic. And so we thought, well, it kind of has ramped up lately that we've gotten an extra amount of calls. So we thought we're just going to have a little refresher here and just visit about it. So we're going to go over the regulations that are applicable here in the state of Oklahoma. We've got the federal regulations. That's typically for our municipalities going to be those employees who may hold commercial driver's licenses. Pipeline. So if you're a gas city, these are going to apply to you. Utility cities basically are going to probably have positions that fall under this. And by the way, if you are a gas city, at omag.org under free services, there is a page link under that list for gas distribution cities. Everything that you would need to pass a corporation commission audit is on that page. Just if that applies to you, know that the resources are there. We worked with the Corporation Commission to get all of that done. And so if you're a gas city and the Corporation Commission comes to Coleman, they're going to say, call OMAG. I mean, we've trained them really well too. So moving on through the federal regulations first. Again, here's the main categories that I think we deal with mostly in our municipal service. Marijuana does remain a drug listed on the schedule of controlled substances for federal law purposes. So we get that question all the time. Well, I have a medical marijuana card, so therefore I can use marijuana. Well, maybe so, but not if you are in a federally regulated job that requires you to be tested. Those are going to be your safety sensitive employees who are subject to drug testing under the DOT regulations. Marijuana is going to pop hot and there's no excuse for it if you are, let's say, a CDL holder. So if you're going to test in the state of Oklahoma or anywhere else for that matter, you have to have a policy that fully explains the drug and alcohol testing program. You have to make the policy available to all employees, and if you are going to, if you've got a policy in place but you're going to amend it, you've got to give that proper notice. 10 days, I think, is what it is, so that your employees know that change is coming if it's a new policy or you've changed something in your current policy. If you need a policy, we have one of those on our human resources page at omag.org. Lots of policies there that are just what I call the plug and play. Just put your city at the top and they're really ready to go. So under the USDOT policy requirements, you're going to have to designate a designated employer representative. So that's going to be somebody, a key employee who is basically responsible for administering your program. They're the one that's going to be the point of contact for the medical review officer, because I hear way too often that whoever answered the phone got the drug testing results. That's not okay. That needs to be protected information. We don't need that just going all around the workplace. That's private, protected information. It's personnel information. So it should not be a topic of conversation outside of those who have a need to know to address it as a potential policy violation. Also, I'll note here that the DER is the one responsible for removing employees from their safety-sensitive duties when they've received a report of a positive test, or if there's a refusal to test, same difference. Okay, so directly affecting the safety of others. That's kind of how we determine who's in a safety-sensitive job. So your CDLs, obviously, that's going to fit within this category, but there may be others. You may have water treatment plant operators. They don't have to have a CDL, probably, but clearly if they're treating our water, they're in a safety sensitive position. Lots of different jobs that could be in your workforce that fit this category. So on our website, we do have a sample. We have this language on our website, but you see it here as well. That I recommend you put on all of your safety-sensitive job descriptions or your CDL job. I'm going to call them safety-sensitive just for ease of our conversation. And we'll talk just in a minute about the Oklahoma standards for workplace drug and alcohol testing. But I recommend you put this language on all of your job descriptions who are going to be subject to testing under either of those regulations, federal or state. Okay, so we'll jump into the Oklahoma Standards for Workplace Drug and Alcohol Testing Act now. Again, you've got to have a written policy. These are the different provisions throughout the Act that talk about the process and that kind of thing for testing in the workplace. And so those are just that's just a reference guide there. So under the state law, you can test under these 6 situations. So applicant testing, or maybe they're already a current employee, but they're going into a new job that is now going to be considered safety sensitive. Maybe they weren't before. So if you're moving them into a job where they're being reassigned to new duties, you are authorized to do what would essentially look like a pre-employment or applicant test, but just make sure that that's included in your policy. For cause testing, we also call that reasonable suspicion testing, and we'll break that down on how to go about doing that, things to look for, that kind of thing. Post-accident testing, so you're allowed to test when there's been an accident in the work on the job. Random testing, again, that's only going to apply. So I'll say that for cause and post-accident, that could be anybody, regardless of their classification, depending on the circumstances. Random testing, again, that's only going to be for those safety-sensitive employees, and that's defined in the Act. Affecting the safety of others. Scheduled or fitness for duty, return from leave, and other periodic testing, as well as post-rehab testing. Those are very similar. Those are akin to one another, I think, or they can be. So if you've got somebody who has had to go into maybe inpatient or even outpatient treatment, I guess, but maybe they've been removed from the job for a while, once they've been referred back to work, usually their substance abuse professional who's been assisting them with the process is going to recommend they need to be tested 5 times over the next year, 4 times in the year 2, or whatever they prescribe. It can be all kinds of time periods, but that's what that post-rehab testing is going to be. And then this one, maybe you have somebody who has been out on a job injury, not related to a drug or alcohol policy violation, but time to return to work. You are authorized, if it's in your policy, to do a test here. Okay, so administering a drug testing program, you're going to do that internally. You need to have your own staff collectors, or you're going to have a contract for that, likely, right? I mean, you don't need to go and hire a bunch of people to collect urine from your employees, but you're going to have somebody who's designated to do that. Through our EAP, we have a list of substance abuse professionals on there, and you can go in on the EAP page and I don't know exactly how to navigate to that, but it's pretty intuitive. And you can type in, here's my zip code. I want to know who the substance SAPs are within a 30-mile radius or a 50-mile radius or whatever it is, and it'll pull up all of the ones that fit those search criteria. So your testing lab would be outside of your organization. Again, that's probably going to be under a contract, likely. Outsource some of the program functions to service agents. So you're going to do that with your MRO, your medical review officer, your substance abuse professionals. All of this is going to be through a contract. And I know MISO was providing this. I think they've sold that now to some other folks. Yeah, what is it called? LGTC. Okay. I just know it's Daniel McClure's wife and father-in-law, right? Okay. So they're the ones running that program now. But there are other ones out there too. I mean, that one's through MISO, so I think a lot of you probably know that one. In my days at the City of Oklahoma City, we contracted with St. Anthony Hospital for all of the services to administer the drug testing program. So all we did in-house was send them and receive the reports back and then deal with them but the whole process of doing drug testing was done through St. Anthony. So you've got lots of possible vendors out there depending on where you are. Just at least have one support staff person internally who can administer that. If you've got a random list that you generate every quarter, make sure that they keep that locked. That's not for everyone to see, right? The only thing, if you go through a third-party vendor for the entire program, is you've got to have that DER in place internally that's going to be your support staff who will receive the call or receive the fax or however that information is communicated to receive the information on the results of the test. So under the DOT, if you're doing DOT testing or testing under the state law, the process looks just pretty much the same. The only difference is going to be under the DOT that some of the thresholds for what constitutes a positive under this 5-panel drug screen might be a little more strict than what the Department of Health has said it would be under the state law. But these are the different categories of testing that they will do for drug testing for a DOT test. And then alcohol is a separate test. So I'll just say if you're doing random testing under the DOT, then you're going to do, some of your randoms will be drug only, some of them will be alcohol only, some of them will be both. And those are set by percentages under the regs. And so just make sure that for drug testing, it's urine only. For alcohol testing, breath, I think, is the most common, but it can also be by testing through saliva. But they're going to analyze the breath. We're not ever going to use urine to test for alcohol. Why is that? Because it metabolizes out of the body. You're not going to get an accurate test by using urine to test for alcohol. So use the breath. That's going to be your accurate testing methodology for alcohol. Now, we get questions too about, well, what about hair follicle testing, or what about drawing blood? You know, if your policy says that, okay, I don't recommend that. Just use urine. I mean, the police may, if it's a criminal matter, they can do what they need to do criminally, but for employment purposes, urine is how we're going to deal with drugs, if you ask me. Okay, so the Oklahoma Standards for Workplace Drug and Alcohol Testing Act applies to municipalities. It does require that written policy, and again, there are the different types of testing that are authorized under the Act. Just make sure you have them all listed in your policy. So we're break these down one test at a time. So pre-employment testing, you can conduct that pre-employment. It's contingent on the, that would be your, give them a job offer. I just want conditional. Why was that? Words are hard today. Yeah, so go through your normal process, but this can be, you may want to do a health screen. I hear that some folks still do those, some don't. But for sure, police and fire. So then the MRO, your medical review officer, is going to be the one who reports the test. Again, you're authorized to do this if they're changing jobs over to a safety sensitive. Alcohol tests, you would do that for everybody. Post-offer requirement, again, that's required for any time you're going to do any kind of medical look into a person. And then if it's a DOT, you're going to do that history check for the past 2 years, and you have to have written consent to do that. You all may be asked by other employers to provide information on a history check for maybe a former employee. Just make sure that there's written consent for you to provide that information. Okay, applicant testing, again, you can require this. Just make sure that it's listed in your policy. So that's a little redundant from the previous slide. Okay, so random testing, you can do that either under the federal law or the state law. This is supposed to deter employees from the use of drugs and alcohol. I hope that it does. I hope that we wouldn't have to have this in place to do that, but reality says otherwise sometimes. Just again, I can't stress enough that this has to be in your written policy. And we haven't talked about this, but this is employees only. So on the previous slide, it talked about, firefighters, they're going to be your safety sensitive. Now, if you've got collective bargaining agreements for police and fire, this has to be negotiated. So you can't test them unless it's been negotiated. So hopefully that's in your contracts if you have them in place. But if you have volunteer firefighters, cannot test them. They are not employees. So while they are out driving big fire apparatus and doing all kinds of hazardous things for your municipality, they are not employees. It's a violation of their constitutional rights for you to test them if they are volunteers. So just either one, you cannot test them under the federal or state law for drugs or alcohol. Yeah. Even voluntarily, don't do it. They may say, oh, take all my body fluids. No, don't do it. It's a violation of their constitutional rights. Why is that? Because we're the government, right? And so Amber will end up with the lawsuit if we get sued by a volunteer who was required to be tested because they're protected against illegal search and seizure. We're the government, so we have to be really careful. That's why we don't test volunteers. Now, I will say that for the last several years, OMAG has partnered with OML to try to get some legislation adopted. I just don't think that our state legislature, for sure, really thought about volunteer firefighters or reserve police officers not being employees. We can't test them. I don't think they thought about that. And so we've worked and worked and worked to try to get legislation passed to no avail. So it's still on the radar, and we'll still keep working on it. Maybe one of these days it'll happen. But in the meantime, just know, can't test volunteers regardless of what they're doing for you, and regardless of whether they volunteer, just don't do it. I think we've covered that. Keep the list confidential. Testing rate 50% for drug testing, 25% alcohol, and I think another 25% can be for both. Okay, reasonable suspicion. This is that for cause testing. So you want to make sure if this is included in your policy that you have trained your supervisors, and William and his staff can actually come out and help with this, right, Will? Yeah. So they can come and train your supervisors if you need that in your city or town. But you want to make sure that they've been trained to know how to recognize. And we're not asking them to say, oh, you're under the influence of something, but the training is, what are you observing, right? So we'll talk about that. But you recognize signs and symptoms that may tell you that there is some sort of an impairment. You don't have to know what it is, but it's just you're gonna be able to establish the cause for getting them in and getting them a test. And it could be that the test comes back completely negative, but maybe they were in we've had this happen lots of times where maybe they were having a diabetic incident and they appear to be under the influence of something, but it's actually a medical emergency. So, but that we're not out trying to diagnose anything or anything like that, but we just are gonna, what can we observe, and we're gonna write it down. So we'll go through what that looks like. So for DOT, the criteria of signs and symptoms is listed here. So contemporaneous, so it's happening right now. And I recommend that you get 2 supervisors to observe this. I don't rely on just one. If you can at all help that, really is best practice to have 2 independent observers articulate what they are observing with this employee who is believed to potentially be impaired. But articulable, so describe what you're seeing. Objective, so is clear to everybody who, or at least the reasonable person would see it. How does he look right now? How's he acting right now? Words, are they slurred? Do they smell of alcohol or maybe marijuana? All of those things would be things that you would want to write down as your basis for sending somebody out for a reasonable suspicion or for cause test. So what is reasonable suspicion not? So declining job performance. So there may be an issue related to some kind of substance abuse if there's declining job performance, but that's not going to be a basis for getting them tested. Attendance and tardiness problems. Possession, just because they have it doesn't mean they're using it. So we got to have articulable, observable signs about their person in order to be reasonably suspicious and have them tested. Third-party reports, even if they're reliable, we're just not going to do that. We want to have our supervisory staff observing and writing it down, sending it to HR, who's then going to send them out for a test. Accident or injury, that's not going to be the basis for a reasonable suspicion test, but maybe we have a post-accident test depending on the circumstances. If it's just a cut finger, probably not, you know. So a car wreck, we're going to probably test. All right, so how do we make a reasonable suspicion determination? Step 1, we're going to look at them. Step 2, we're going to document. We're going to write everything down that we've observed at what day, on what day and what time. We're going to lock it in. Then we're going to report it over to the designated employer representative. That's going to probably be you all here if you're responsible for administering the drug program. You're going to discuss it and you're going to be discreet, but you're going to write it all down. So here's some things that you can maybe look for that are specific to the person. So look at their eyes. Are they red? Are they constricted or dilated? Droopy eyelids. Body clues, so sluggish, staggering, nodding or falling asleep, looking for something to lean on, jerky or twitchy, shuffling, scratching, or picking at their skin. So that may be something. I know we talk a lot about marijuana. We got a lot of things that could be happening here with this person. Muscle cramping, chills and sweating, needle marks, lack of pain sensation. So these, each one by themselves may be nothing, but you start adding things up, right? So then, to me, this is the biggest one, the verbal and facial clues, so slurred words, speaking quickly and incessantly. I mean, that might just be a normal day in the office for me and Lori some days. But you know, I mean, if it's out of the ordinary, then maybe today. I don't know. I haven't had all my coffee yet. So rambling speech, again, you know, isolated moments of things like this, probably not, but things do start to add up. Unable to focus, wants to tell you how to fix the world. That's an interesting one. I don't know. There's lots of us that are fixers. Falls asleep, nods, increased sense of taste or taste perception. These are all things that we might dismiss, except if we've got something happening with an employee, these are things that we're going to want to observe and not dismiss and not pass off as just, oh, they're just having an allergy day maybe. I mean, write everything down, right? Just write it all down so that way it's a clear picture of what's happening with this person. Emotional clues, hallucinations, paranoia, memory problems, exaggerated feelings, lack of inhibition, irritability as the drugs wear off, reduced sense of reality, hearing colors. I've never experienced anybody who was having something like this happen in the workplace, but it could happen. It could very well happen. Then you've got sensory clues. So smell of alcohol, or smell of marijuana, smell of inhalants. I guess that's still a thing. Odd smells that indicate the addict is trying to cover up the smell of smoke or alcohol. So you may have somebody who's been drinking alcohol and then they come to work and I mean, how many times have we encountered this where they're eating a whole package of mints or, chewing gum or they've doused themselves with a bunch of cologne to try to mask the smell of whatever they've ingested or inhaled before they came to work. So that's something you would write down when you're trying to establish that there's reasonable suspicion. Is it a violation of the policy for them to eat a whole package of mints? No. But that's something that you're going to observe and you're going to write it down. And when combined with all of the other things that were on these other pages, that helps you to establish your reasonable suspicion to test. Okay, so reasonable suspicion for cause testing, you're going to observe if maybe you have observed drugs or alcohol on or near them, observe the conduct that suggests that they're impaired. So those are all those clues that we just talked about. You're going to you might receive a report of drug or alcohol use by an employee. So if you have an employee come in, I mean, this may not happen on the first time around or the second time around, but at some point, coworkers are going to start to get a little bit antsy about working with somebody, especially if you're working out in the field or doing things that are safety sensitive. Then their safety's at risk, right? So at some point, they are going to be inclined to come in and report that. So make a report of that. Maybe have them write down what they've observed, but you're not going to use the coworkers' observations as your basis to reasonable suspicion test. You're going to send a supervisor out, preferably two, independent of each other, to write down those independent observations to see if, in fact, they are seeing what the coworker has reported. Negative job performance patterns. All of these can be part of the overall issue of what's happening with this employee. But in and of itself, negative job performance alone is not going to get you there. But again, the absenteeism or the tardiness, that could be part of it too. I mean, if you've got somebody who's using substances or alcohol of some sort and trying to do their work, you're going to have these visible things about their person, but it can't help but spill over into their work performance. So those are things you're going to document as well. So if you've got a situation where you're going to need to send an employee to be tested, be discreet, call them in, don't make a huge spectacle of the situation, but you're going to send them for a test. If it's a reasonable suspicion test, don't allow them to return to work until they've received a clear test. If it's random, no advance notice. I hear this all the time. Oh, we're going to do our random test. The van's coming out. We're going to do the random testing on Friday. Well, that's helpful to the employees, not really a random test for you, which then concerns me, because if it's not a truly random test, then what's your basis for testing? You don't have a reasonable suspicion. So it really does need to be a surprise when they're called. Okay, so this is important here. How much time does an employee have to report for the test? They have to go immediately. And how many times do we have a supervisor who says, oh, I can't spare them right now, and it's several hours, and then they go? Absolutely not. That's a problem for the supervisor, and that should be addressed. When you have an employee who's called to go for a random test or whatever kind of test, they must go immediately. Do not delay. Go. And this is especially important if it's a reasonable suspicion test. Really, any kind of test. I mean, we want them to go right then. We want to know what's going on with them in that moment in time. So the passage of time is not your friend. It's their friend. It's not your friend. So we want to know what's going on right now. So get them going. And if it's a reasonable suspicion test, don't let them drive. Take them and wait for them and bring them back. And make sure that they have somebody who can take them home if they're impaired. And I mean, obviously there's something. We don't want to let them drive. So just keep that in mind. And this is something that needs to be in your policy. Making it clear to your employees that there are consequences for failing to appear within a reasonable time. That's going to be considered a refusal, which is as good as testing positive. Yes, sir?
So what if you have one that fails on a reasonable suspicion,
Mm-hmm.
fails, and another intoxicated,
Mm-hmm.
and you get back to the place of employment, they refuse to ride, and they insist on driving themselves. Should you take an action?
Yeah, I just would not let them drive. Call their emergency contact, or, I mean, they're still at work. Give them a directive that you're going to take them home.
What if you offer all that and they still not leaving?
I mean, I don't recommend putting hands on them. I mean, I don't recommend that, but I think that you just tell them, I cannot let you go in your car. And if you insist, then, I mean, if they get in their car, I'd call the police.
I just didn't know if it was unreasonable.
I mean, if they're intoxicated and they get in their car and insist on driving, I mean, you're not going to feel good about them pulling out onto the roadway and hitting somebody or killing themselves or somebody. Call the police. Yeah. Oh, yeah. Well, and you know what? That'd be okay too if that's possible. Safety is the number one concern there. You just don't want to risk it. Yeah. Sure. All right. So here's a reasonable suspicion checklist, and so I think that this is also on our website. Well, and you're going to get this in the PowerPoint, but I think we actually have this form on our website. This kind of helps you establish the reasonable suspicion. You can kind of go through here, and it kind of helps you figure out what are my observations, and just check those boxes and see if they add up to a basis to test. Are there any questions so far? Okay. So positive tests. So if it's a safety sensitive and you've received a positive, well, if it's a reasonable suspicion, they will already be off work. You're not going to let them back until they get a clear test to return, and you deal with all of that. But let's say it's a random and they don't show any outward signs of being impaired. So they've gone for their test, they've come back to work, they've resumed their normal duties, and then within whatever the time frame would be, you get a report that it's a positive test result. Well, then you're going to, if they're safety sensitive, you're going to remove them from their job. You're going to give them a list of the substance abuse professionals that we have from our EAP. And, you know, you could go ahead and print a list. It changes from time to time. So you'll want to, if it's been a while since you printed it, you might want to just double check and make sure the list is still accurate. But you want to give them a list of the substance abuse professionals from the EAP. And it'll tell you on there, those substance abuse professionals on the EAP list, it'll tell you what their certifications are. So if they're certified under the DOT, it'll say that on there. I think most of them are. Well, so yeah. So, and there shouldn't be by the time it's reported to you. So the process is that you'll have your initial, there'll be an initial test, and then there'll, if it meets thresholds for initial test, it's going to go, this is all done in the lab, it'll go to a confirmation test, different thresholds there. Once that comes back, it's actually from the lab should be deemed a not negative test. They're not going to, they shouldn't tell you, oh, it's a positive, because who makes that determination? The medical review officer. So once that not negative test comes out of the lab, it's going to go to that medical review officer, MRO. And then he or she is going to look at this, and it'll tell them that they've met the thresholds for marijuana. They're going to call the employee, and they're going to indicate, they're going to tell them, hey, MRO here, you tested with levels of marijuana in your system. What say you about that? And then they'll say, well, I have a medical marijuana card, so it's all good, right? Well, no. Not if you're in a safety sensitive job, right? So, but let's say it was a reasonable suspicion test, not of a safety sensitive position, test positive for marijuana, goes to the MRO. Hey, you tested positive for marijuana. What say you? Well, I have a medical marijuana card. Oh, okay, well, I need to see that. This could be for anything that is a prescription. Maybe they're on hydrocodone and they've hit the thresholds for the opiates. But if they've got a prescription and their levels don't indicate that they are using more than is prescribed at those therapeutic levels, they're going to report it back as a negative. So when we say false positives, I'm not a big believer in false positives, because it should have been fully vetted through the medical review process. That doesn't mean that they didn't have something in their system. It just means that it's going to be excused through the MRO. Yeah. Yeah, I was at a party where there was a bunch of secondhand smoke. I ate a plate of brownies, and man, they were so good, but apparently they had marijuana in them. I have litigated all those cases. And I'm going to tell you, arbitrators love that stuff. But scientifically, it just doesn't bear out. But if you end up in an arbitration situation, because maybe it's a police or fire, they're just waiting for some reason to excuse the behavior. But there are studies upon studies upon studies that my favorite is the secondhand smoke where they put a bunch of people in a Volkswagen Bug, and then they just piped in all kinds of marijuana smoke in there. It's just a big old fog, Cheech and Chong all over again, right? And then they tested them, and they did not meet the therapeutic levels. I mean, they did not meet the levels for it being a positive test. Don't you love that?
I do.
Yeah.
Yeah, and then even for its retro, it's like 2.5 hours of continuous exposure. So there's glancing, I walk past Johnny smoking a blunt.
So that actually happened to me. I went float the river one time, and the bus taking its bag. That was exactly what it was.
That's a long exposure.
Like, when we got on Saturday, that Monday morning, I was around it. And I absolutely lost my mind.
Well, so see, the science was right.
It worked.
Trust the science, right? Yeah. So, and even, yeah. So false positives, the whole poppy seed thing.
So you'll get an employee who's denied to the T, like, no, that can't be right. How do you proceed on that? This is what it's saying. I'm sorry. This is what we're going to do.
Yeah, because they're always going to say, oh, this can't be right. So you've got the, well, so here's the thing. Under your policy, you should have the ability for the employee to go and get a second test at their own cost. If it comes back that it's negative, I've seen policies that say you'll reimburse for that. I think that's pretty standard. I think the sample policy we have on our website says that, if I'm not mistaken. But that's the employee's recourse. If they come back and say, there's absolutely no way, I haven't smoked any marijuana, I haven't had any opiates, I haven't done any of these things that it's saying that I've done here, then you give them the process, make them aware of the process, and have them go and utilize the process and see where it falls out. But until they are able to show otherwise, if it was reported back to you as a positive, you've got a policy infraction that you're going to deal with as a performance problem. Yeah.
Like how long? I mean, a certain amount of days, something might be out of their system, depending on what the drug is within without a second test.
But there is a time limit. You know, I should. Yeah, it does say that, Lacey.
I was going to decide that there, the LGBTC also came down and did kind of similar to this, and they said that if an employer is going to do a retest, they retest at some sample. They don't retest.
That's why they do a split sample. Yeah, that's why they do a split sample. Yeah. Yeah. That's exactly right.
Have you ever had someone take you up on the split sample?
I have.
You have, because and even when I was in private industry, when we offered the split sample for someone who was saying, hey, you know what, my test's negative, I never had anyone take me up on it.
Yeah, I have, and so far I haven't had any that were changed. Now, where I have had some issues on that split sample is chain of custody issues. So make sure that whoever you're using for your testing services, make sure that they are maintaining a proper chain of custody. I mean, that is so critical, because if they don't, what good is the split sample? If they can't show that it's gone from here to here to here, you know, and you can prove that, and you can prove that it's been properly preserved at the right temperature and all of that stuff. So you've got to have a testing service that's really on top of the requirements for that. Because if it spoils, or if they can't prove a proper chain of custody, it's useless, and you're going to have a big fat loser on your hands. Yeah.
So what if they're a seasonal employee?
Mm-hmm.
You treat them the same.
I mean, if they are in a safety sensitive position, it doesn't matter if they're full-time or part-time, as long as they are an employee. Yeah. Any other questions about all of that? Okay, the big question, can I fire an employee who tests positive? It's your decision. What's your policy say? Because a lot of times we'll say, oh, we have a no tolerance policy. But then we have, first infraction, second infraction. Well, that doesn't sound like no tolerance, right? So whatever your policy says is what you're going to do. Again, don't forget, if you've got collective bargain, what does it say? It always it amazes me in like police contracts where they want to have all kinds of chances to test positive, and we want them to get help. So see, that's the thing. This should never be treated as a punitive program. If you've got somebody who's using drugs or alcohol and coming to work, we should not be playing gotcha. We should be helping them. Again, this is why the EAP came about for OMAG to begin with, was because we had so many of our members out there who were doing drug and alcohol testing, who may have not even had a policy in place. So we fixed that. But then if you're doing drug testing, you have to have an EAP. Well, so you have one. That was why this came about to begin with. I've seen provisions in the firefighter contract at Oklahoma City. They had what we called the King's X. So if they were called in for random testing, and they knew that they had been in a bus all weekend breathing in secondhand marijuana smoke, they could come in and say, I have a problem, I need help, and not test, and go right into EAP and get their problem addressed. But they have to admit they had a problem. So lots of options in your policy, but it's a policy call. It's whatever suits your city or town, or utility. It's a policy call. So there's no one answer, no one's right, one's wrong. I mean, it's whatever suits your workforce. So do I have to provide SAP treatment services? No. Substance abuse professional services? No. You don't have to provide that, but you have to provide a list, which you can do through the EAP. So if you have somebody who tests positive, put a list in their hand, or tell them, the easiest way is put a list in their hand. Then that way there's no question about it. So the substance abuse professional will meet with them face to face. They're going to talk about whatever is going on with the employee. They're going to make recommendations. They're going to prescribe whatever is needed. It might be inpatient. It might be outpatient. It might be some counseling sessions with ongoing Alcoholics Anonymous, for example. That's a real common one. They're going to evaluate them. They're going to decide when they're ready to return to work. And then they're going to make a recommendation on that post-rehab or that follow-up testing. And they're going to tell you how many times, or they should tell you this person needs to be tested once a month for the next 12 months, then once a quarter for the next 2 years, and then they can go as far out as 5 years. So they're going to tell you what you need to do. So a refusal to test, and who determines a failure to report at a urine collection site? That's a refusal. Failure to remain there. I mean, these are all examples of what would be a refusal to test. And a refusal to test is as good as a positive test. You're going to treat it the same way. So it's a policy violation. So this is a good one. We went through a wave. I don't know if it's still an issue or not, but the Oklahoma City Gazette. Do y'all remember the Gazette? I don't even know if they still have it. There used to be a whole section in the back of this it was this newspaper that they had here in Oklahoma City, Forever and a Day. You could turn it, real trendy looking thing, kind of artsy. But at the back of it, they had ads. What? Yeah, I guess that's what you would call it. But they had a whole section on how to fix your test. And so these guys and gals would go on there, and they would get, they would be feeling like, oh, my number's up or something, and so they would always be prepared to adulter their test, because you never knew when you were going to get called. And so I can't tell you how many times we would get reports back that invalid specimen, wrong temperature, might be too cold, might be too hot, might not be human. And that was what a lot of these were selling, was pig urine. Because I guess pigs are the closest to humans, or can be. I don't know. Anyway, kind of weird. But yeah, so a whole section of classifieds in the back of the Oklahoma City Gazette to help you fix your test. I mean, it didn't work because the labs were onto it. I mean, really? So, then, have employees say, well, I paid $100 to this company to help me. Like, well, okay. Yeah, so it just gets better and better. But if you could find them, right? If you could find them. But all of these are a refusal to test. It's a violation of the policy, just like a positive would be. So you're going to deal with that in the same way. Yeah. Uh-huh.
You have someone who you sent to get the urine.
Yeah. Uh-huh.
They tell them that I can't wait. I go, we all know that that's a
Yep.
So this person leaves, and so you try to tell your city manager at the time, that's a violation. They do not get hired. You have a right to.
And he hired him anyway.
He hired me.
Okay. Yep. So the problem, there are lots of problems with that. But if you're going to do it for that one, then, what good at some point, what good is your testing program, right? So if you have an employee who goes to provide their sample and they can't go, there's a whole protocol there at the collection site on what to do if they can't go. Run some water. But, they're going to and that's the other thing. If you have somebody here that's adulterated, or it comes back not human, or it's too cold, too hot, or whatever, they're going to be observed the next time they go. We have trust issues when we have things like this happen. And so we're going to observe the collection of the sample. But if they can't go, there's a whole protocol on how to deal with that, and they're going to give them a glass of water. Now, we're not going to let them chug a whole bottle of water, but we're going to give them a little bit of water, because what happens when, that's another way to adulter a sample. Chug a big gulp of water before they go and provide their sample. It'll be diluted, and that'll be reflected in the sample. So that again is going to cause them to be observed when they do their sample. But their whole protocol if they can't go. So leaving the facility is not the answer. They need to stay, and if you can't stay, then that's going to be a refusal to test, and you just need to make that clear to them that they understand the consequences. But if you're going to hire them anyway, hardly consequences, right? So just make sure it's in your policy and just stand on that. Yeah. Other questions about that? Okay, return to duty. Okay. We're going to keep going, and then we'll break for lunch when Kaylee says it's time, and then we'll pick back up, because we've got some, let's talk about it after we get through the main content here of the day. So return to duty and follow-up tests. So this is going to be done after you've had an employee who's tested positive. They've gone through their SAP stuff. They're ready to return to work. The SAP will order this. It has to be negative or they should not be allowed to return. So here's what I've been talking about. The SAP can order that follow-up testing, and it can be up to 5 years, and it can be as often under these guidelines as the SAP thinks is necessary. Again, those are unannounced. So here's the best way to do those. When you get that report back from the SAP that says, okay, ready to return to work, he's presented a negative test, I recommend that you do this much testing over the next year, next up to 5 years, whatever it's going to be. Set those dates and just put them in a folder. Don't tell anybody. It's your secret. And then that way it's not going to be that accusation of, oh, you're just trying to play gotcha again. These are going to be a pre-established calendar of when you're going to send them for follow-up testing. Now, if they are on the random list, which they likely are if we're going through all of this anyway, they're still in the random pool too. So they're subject to being called on a random, but they're also going to have this scheduled or follow-up testing that only you're going to know about.
Can you explain that to them?
No. Well, explain what?
That they're going to be tested every so often?
Well, so they should know that their SAP has said, I want them tested 6 times over the next 12 months. So they should know that they're going to be subject to this follow-up testing. They should also know that they continue to be in the random pool, which you have no control over. They may show up again on that next random list, but don't tell them when you're going to call them. Yeah. That they're free and clear? Nope. They need to understand. Yeah, they need to understand that they're subject to this follow-up testing as prescribed by the substance abuse professional, and that they are going to be tested periodically throughout the year, but they'll never know when. So keep it clean. Yeah. Oh, and if it's been a random and they've gone through the SAP program and you're doing the follow-up testing, they are observed. Yep. It's here. Okay, let's see where we are. I don't know how many slides we have left until we get to the let's talk about it, but the food is here. So let's get through the next couple of slides here, and then we'll go in there and eat and come back. So anyway, this tells you about the collection. So here's that split sample. They're going to take that sample, their cup of urine, and they're going to divide it in 2, and they're going to seal one and keep it really safe, and with that chain of custody and all of that stuff. And then here's the requirements if they want to do a test on the split sample, 72 hours following the positive test. The MRO should offer that. If not, the employee have it in your policy, so hopefully the employee will know to ask, or you can tell them. It's not a secret. And this has to be done regardless of who pays. So maybe it's the employee's responsibility, maybe it's yours. That's all set out in your policy. Okay, we'll go ahead and start back up, and we'll go into record keeping. So what drug and alcohol records do we need to keep? We want to go back 5 years, keep a rolling 5 years. I think that's best. And you're going to want to keep records of your alcohol tests indicating an alcohol concentration of 0.02 or greater. That's under the DOT guidelines. If you are managing a policy that's just under the state law, you may designate that as what would be the threshold for alcohol. It might be higher. So whatever your policy says on that. So you'll want to keep records of what's been verified as a positive drug test result, any refusals, Annual reports, SAP reports, all follow-up tests and schedules for those follow-up tests. So keep all of those records in a safe and secure location for 5 years. For 3 years, information obtained from previous employers regarding drug and alcohol results of employees, that's going to be for your DOT folks. 2 years, records of inspection and maintenance and calibration of those breath tests machines. Anything related to the collection process. So if these are through a vendor, you're going to need to address that in your contract. And I don't know of anybody who does that themselves. So that's going to need to be addressed in your contract. And then 1 year, any negatives or canceled drug tests with a concentration of less than, that should be a point there instead of a slash. Sorry for the typo there. Where and how do we keep testing records? Lock them up. So these are highly confidential records, not open for inspection for anybody except the person charged with keeping those records. Really, should be the only person who has access to those records. That doesn't mean that you don't talk to a supervisor about what the test revealed. Obviously, that would be a need to know. That's that second thing there. But the records themselves, it's better to keep them locked and just have a custodian who's in charge of those records and leave it at that. So the MROs have their own requirements on keeping their records. And so make sure if that's addressed in your contract with your vendor. And then here under the DOT, if they come calling, you've got to show them any records that are for those employees who fall under those regs. I haven't. Yeah, I haven't. They're probably busy doing other things. If the Department of Labor comes calling, they don't have any need to be looking at your drug records, but that I wouldn't let them look at anything until you've called your city attorney, just as an aside. Will?
No, private industry, yeah, I'm not putting any of this. I was putting a lot of private orders.
Yeah, I mean, I just saw that on there. And I thought
Yeah.
that's-
They can. They're probably busy doing other things. Yeah. 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 Okay, medical marijuana. So we've had it around for a bit now, haven't we? Since it was legalized for medical use back in 2018 and signed into law early 2019. I should have changed that. It took effect in August of 2019. It's still illegal under the federal law, as we said at the outset today. And legal risks remain for those using it for medical purposes, even though it's in compliance with state law. So if we've got somebody who is presenting as impaired in the workplace, let's say they're not safety sensitive, and so we do a reasonable suspicion test for them, it may come back and should come back. I hate when these facilities leave it up to you to decide whether you're going to treat it as a policy infraction or not. It's really their call to make. If they validate the test as legal use because it's medical, they're not DOT or safety sensitive, they should report it back as a negative, in my opinion. I know there's a divide on who agrees with me and who doesn't, but I don't think that's your call to make. But if it's returned back to you that it's positive, but the medical marijuana card has been reported to have been in place by your facility, you're going to treat it as a performance issue, not as a policy infraction under your drug policy. If they've got a medical marijuana card and they're not in a safety sensitive job. Safety sensitive, all bets are off. It's not a free pass. But if it's a reasonable suspicion or one of the other tests that's not a random and they're not a safety sensitive or DOT, CDL, then you're gonna have to make the call if the lab has not done so. If the lab reports back that it's negative, and they shouldn't probably tell you that it's because there was a medical marijuana card in place, they're just going to tell you it's a negative, then you're going to deal with it solely as, I mean, there's a reason you sent them, right? You went through that whole exercise to establish a reasonable suspicion to test. Well, if it comes back negative, that doesn't excuse the behavior, right? So you're going to deal with it as an infraction, as a performance problem. Okay, so to administer your drug and alcohol testing program, if you've not already done so, get your job descriptions up to date and put that language on there. If they're safety sensitive or under the DOT that we talked about in the beginning, it's on our website. And put that at the top of every job description you have that fits that criteria. Update your policy. So if you are using the OMAG policy that's on our website, and if you've not already done so, it's been revised to incorporate a whole section on medical marijuana. So that's out there for you to use. Again, 10 days notice if you're implementing a new policy or making changes to your current policy. Make sure that you've confirmed with whoever's doing your testing for you that have a meeting of the minds on how they're going to handle those tests that come back positive for marijuana and they're not safety sensitive and they have a medical marijuana card. Good time to address that is when you're entering into the contract. So pin that down and then train. We always say training. As I said, Will and his group can come out and assist you with training your supervisors on how to establish reasonable suspicion. What does that look like? We've given you the checklist out there. It's on our website. It's in this material that'll be posted today or soon, within the next day or two. Just make sure that everybody understands their roles and responsibilities under your policy. Okay, so under the Medical Marijuana Act, it's unlawful to refuse to hire somebody, discipline, discharge, or penalize solely for being a medical marijuana applicant or licensee. So don't ask if they have one. So if it's a safety sensitive job and you put that language at the top of the job description, then don't say, do you have a medical marijuana card, because you're going to be randomly tested or subject to random testing. Just give them the job description and say, here's the requirements, and it's going to be right there at the top. Can you do this job? It would be just like anything else. Sure, yes, I can. Okay, sign it and let's get to work. Because that's not going to be the basis for taking an employment action solely by itself. If they're not a safety sensitive, if they are a safety sensitive job and they test positive for marijuana because they have a medical marijuana card, that's another thing to address in your contract, because that should not be reported as a negative. The medical marijuana card is not going to excuse their positive if they're in a safety sensitive job. So make sure you pin down what the expectations are as far as reporting out a positive or a negative when there's a medical marijuana card in place. So if they tell you that they have one, because they want to talk about it, you can tell them you can't do this job. and if they test positive, it's not going to excuse them. So just put that language at the top of the job description. Make sure you've got it covered in your policy, and you should be good. Do you? How so? I mean, what does that look like? Mhm. I think that's okay. You're not saying, so do you have one? Yeah. Yeah, don't ask. But yeah, I think that's good. Get it out of the way. Yeah. Good. Yeah. Yeah. That might save you some time down the road, right? And we don't want to invest in somebody that's not going to be successful. Yeah. So an employee can be disciplined if they obviously they don't have a card and they test positive, or they possess, consume, or you can limit their activity for use of the marijuana while they're at work. Even if they have a card, that's not a free pass to use while they're at work. So that should all be covered in your policy, right? Okay. And then, of course, if it's safety sensitive. Okay, so on this safety sensitive issue there, it says narrowly, should be construed to narrowly limit the overall number of job positions that qualify. You're going to base that on the duties that they're performing. So you may have some laborers who, I mean, I don't know what that would look like, but they might not really meet safety sensitive. So it's got to be based on the work they're doing. Okay, tell me what you're thinking. Yeah, I can't either, but that's what it says. So, but yeah, job duties of each position. I'm trying to think.
What some employers do is they try to make every job safety sensitive. That like you're sitting at a desk all day doing data entry. What makes that job safety sensitive?
So, for example, like in a gas city, we know that the Corporation Commission views the office clerk as safety sensitive. That doesn't seem reasonable. Office clerks really aren't safety sensitive. So why in a gas city are they deemed to be safety sensitive? Because they're also dispatching the work and taking in the calls, and we don't need them use. Yep, yeah. So that would be an example. So if in another department within your municipality, probably the office clerk is not going to be safety sensitive, but in the gas department, they will be. So that would be an example, I suppose. And they weren't always, and the Corporation Commission called and said, hey, that's a no-go right there. So we had to kind of change our thinking on that a little bit. So again, just analyze the job duties for each position. And in the state law, it really explains it in the Medical Marijuana Act. It's got a long list that's more expansive than the one that's in the standards for workplace drug and alcohol testing. I mean, you gotta pass that first, but then this gives you even more tools to decide whether or not this truly is safety sensitive for purposes of that act. Okay, so this is just where all the different places where you'll see safety sensitive defined. So again, the Oklahoma Workplace Drug and Alcohol Testing Act and then the Medical Marijuana Act, they both have provisions that define what that looks like. And then under the federal law, we've got DOT and then PHMSA. This is for your pipeline folks. So this tells you that the Medical Marijuana Patient Protection Act, duties that the employer reasonably believes could affect the safety of employees, so that you really have to drill down and know what that job is really going to entail. If they're handling or transporting hazardous materials, that seems kind of like a no-brainer. Operating a motor vehicle. Now this one we have to be really careful, because if it's the office clerk who has to drive to the bank or to the post office, that's not going to be enough. So you want the driving to really be inherent to the job they're doing in order to make this safety sensitive. So if it's just, once a day or every other day or whatever, just to run a quick errand for the office, that's not going to be enough, I don't think, to meet this one. Here's some more duties that are set forth in the Medical Marijuana Act. Repairing or maintaining any equipment. And a lot of times, really most of the time, I think if you've got mechanics, for example, they've got to have certain licensing, likely a CDL. If they're working on CDL equipment, they're going to need to be able to drive it, right? So that's where I could see that one coming into play. Firefighting, obviously. And then here's those utility work. Flammable materials, child care or direct patient care, carrying a firearm, so that's going to get your police. Again, police and fire, if you have collective bargaining, that has to be bargained with them. So here's some best practices to observe when you're dealing with your drug and alcohol testing policy in the workplace and medical marijuana, how all of that fits together. Make sure that the city has a policy. I mean, we can't say that enough, right? Review all your safety sensitive positions and make sure that your job descriptions are really sealed up tightly. Do not put employees in the random pool that are not safety sensitive. So we hear from time to time, oh, everybody's going to be tested. We only have 10 employees. We're going to send everybody. Nope. There's already litigation that's occurred on that. We're not going to test our accountant over here just because everybody else is being tested. So make sure that this is appropriate. Don't ask about the medical marijuana license. Don't say produce it. No, don't do that. Use a reputable testing facility and keep it confidential. Need to know basis is what that means. Okay, samples. So, sample drug testing policy changes. So, this is long and I'm not going to read all of that to you, but this is directly out of the Medical Marijuana Act. We're not going to discriminate against them basically because they have the law or the license. Again, here's that language that we talked about in the beginning, and we just put it in here again to include on your job descriptions. See, and it specifically mentions the medical marijuana. And this is for the job application, so put it on there too, or on your posting. If you're posting it somewhere, put it on there too. Okay, any questions? Because now we're going to talk about some scenarios. Okay, journeyman lineman. You see all the duties that go along with that job. Install, change, transfer, move, and remove poles. Energized conductors. This means something to all of you guys. I know. Over here, yeah. Okay, so can we drug test this applicant? Yeah. Will it be subject to random testing? Can the city ask for the medical marijuana license at any point in the hiring process? Y'all were just listening. And if he tests positive, will the medical marijuana license matter? This is going to be fast. Utility billing clerk. Here's what they do. Collect and process payments from customers, courtesy phone calls, establish new accounts, prepare work orders, make deposits at the bank, other clerical duties. So what do we think? Are we going to test the applicant? Pre-employment. So we can test everybody, right? Okay. Will this position be subject to random testing? Can the city ask for the license? And what happens if they test positive? Is it going to matter that they have a medical marijuana license? Is it going to matter? No. I mean, we shouldn't even know. I mean, if the MRO has done their job, That should not even be reported for this job. But I hear too often that they say tested positive but said they had a medical marijuana card. Your call to make, employer. I mean, I hear that happen too often. So it's still not going to matter as a drug violation. But depending on the circumstances for the testing, it might be a performance issue that you're going to address under a different policy. Okay, we have a water wastewater supervisor who comes to work appearing unsteady on her feet and her speech is slurred. She can't engage in a conversation without seeming confused and is sweating profusely. An employee reports this behavior to the mayor. So we're in a city where the mayor is running things. What are the mayor's options? What do we think? Well, so let's just say we're in an aldermanic city here where the mayor has been notified. Uh-huh. Uh-huh.
Me, it sounds like a ledger issue, but I know I've had those,
Mm-hmm.
so.
First thing you should do is evaluate the situation firsthand. It shouldn't take the employee's word for it. He needs to see it for himself.
Yeah. So the mayor ought to go and make some observations. Uh-huh.
Needs to send somebody else to it as well.
Uh-huh. So we want 2 independent observations. What if they both observe enough to establish that there could be an impairment at play here? Follow the policy, right. So we have a policy that tells us that if we can establish a reasonable suspicion, does it matter at all that it's a water wastewater supervisor? Why? I mean, I think they would be if there's certainly supervising safety sensitive personnel. So I'm going to roll that up to the supervisor as well. I mean, we're not going to let them, be considered differently than those who they're supervising. Okay, so what should be done so we've talked about that. So let's say reasonable suspicion exists. We're not going to assume there's any medical issue. That might come later if the test comes back negative. But as a safety sensitive, assuming that we have firmed everything up in our contract with the testers, they report back a positive. It's not going to matter because it's safety sensitive, right? What if they report back a negative? They shouldn't if they understand and you firmed up in your contract that safety sensitive personnel, this shouldn't matter. So let's say they considered, it was truly, let's say it was negative. We've got all this observable behavior. She had a medical marijuana card. It didn't matter. But it was negative. Well, so then you got a performance issue, right? And so then you're just going to proceed with a conversation with the employee. And maybe, she's not going to be allowed to return to work because she was tested on a reasonable suspicion, right? She's got to come back with a clean test. And let's say she does that. We've still got a situation to address here, right? But if she tests positive, this isn't going to matter. Yeah. Okay, you have a mayor who's decided it's time to randomly test all employees. The town clerk is selected in the random drawing. The clerk has a medical marijuana license and uses it every couple of days for arthritic pain. The clerk is reluctant to test because she does not want the mayor to know she has a medical marijuana license. So can she refuse to do the test? Who said no?
No, she's not subject to randoms.
She shouldn't be. So we've got a mayor here who's pulling some. So if the policy says all all employees are subject to random testing. That's the first thing that needs to be addressed. But she can tell the mayor, I'm not subject to random testing. You're violating my rights if you do this. There's a case on that, City of Miami, I think. Tested the finance director. Yeah. So, is the position subject to drug testing? Well, it's subject to other kinds of drug testing, just not random. So she could be tested for a reasonable suspicion or some of the other categories, but not for random. See the difference? Okay, so that answers that next question. If the clerk tests positive, will a medical marijuana license matter? It should matter. Yeah, it should be reported back as a negative. Really? Yeah. But if if she's, again, it's not going to excuse her if she's actively using it at work or if she's somehow impaired while she's at work. It's going to depend on the circumstances for the test, right? So under a random, all other things equal, should not matter. But if she's not performing in a manner that she should be, that's not going to save her. It's not going to excuse her failure to perform. Okay, we have a job posting for an administrative assistant. The duties include assisting the superintendent in day-to-day administrative activities, general office duties, including answering the phones, and occasionally dispatching calls for natural gas emergencies. I kind of already talked about that. But can the assistant be drug tested? Yeah, I think that anytime we're dealing with potential for these kinds of job duties, they're going to be considered. Our Oklahoma Corporation Commission is going to consider them safety sensitive. Is the position subject to random drug testing? Again, yeah, I think absolutely should be. Those are kind of the same. If the assistant tests positive, will a medical marijuana license matter? Because if she's safety sensitive, no excuse. The results are going to be what they are.